Hello friends, today we are going to discuss about the Assisted Reproductive Technology Act of 2021. I am Dr. Suresh, Bada, Professor of Psychiatry, working at NIMANS, Bangalore. Before I start my presentation, I would like to place this disclaimer. This presentation is for academic and training purpose only. This is not a substitute for professional legal opinion. For professional opinion, please do contact an advocate. Conflict of interest? None. In this video, I'm going to discuss about assisted reproductive technology. What does it mean? What are different types? What was the need for this Assisted Reproductive Technology Act 2021? And let's critique whether how best this legislation is going to achieve its objectives. And this video is targeted to doctors, gynecologists, hospitals, nursing homes, ART clinics and bank, nurses, and public at large. Assisted reproductive technology. In short, from here onwards, I'll be calling it as ART. ART refers to medical procedures that aim to achieve pregnancy. As the medical science is advancing, even the ART technology is also advancing at a rapid pace. Now, it has become very complex. Hence, this ART is a complex treatment of manipulating or influencing gametes, eggs, or sperms to increase the chances of fertilization. In simple words, you can call it as it is a medical treatment for infertility treatment procedures. Why are we so worried about this? If you look at the global assisted reproductive technology market, in 2018, it was just $21 billion, and it is projected to be $45 billion by 2026. That means there is a huge market for this. Approximately 2.6 crore couple are looking for this treatment. That means there is a huge market. At the same time, when there is a huge demand, there is a possibility of misuse of this technology. Let's look into this advances in ART. There are two types, invasive and non-invasive. Basically, if the surgical procedure is used, then it is called as invasive. Non-invasive, where the medications are used. But invariably, it is a combination technology that is both medical and surgical is used. Some of them are basically intrauterine insemination. Here, the sperms are directly introduced into the uterus. In vitro fertilization. Here, both the gametes are taken and mixed in the lab in a controlled environment and placed either in the fallopian tube or the uterus. The next important is intracytoplasmic sperm injection. As it says, here the doctor is going to take the sperm and is going to inject directly into the oocyte. The further gamete intrafallopian transfer, it is also called as gift, where you are mixing the gametes and then placing it in the fallopian. Similarly, zygote. Here, the zygote is placed directly into the intrafallopian transfer. Further, pronuclear stage tubal transfer. It is basically the embryo at what stage you are going to place it. Further, depending upon the number of division, either the single embryo, triple, quadruple, depending upon that, it is also called as a transfer. And again, the stage of transfer, is it blastocyte or cleavage stage embryo transfer is used. Along with this, now the newer technology in the past 5 to 6 years is frozen embryo transfer versus fresh embryo transfer. Nowadays, the technology has become so easily available even in class 2 tier cities in India that frozen embryo technology has also been used. Now let's enter into this assisted reproductive technology, ART. We can consider in 5 steps. Based upon the 5 steps, you will be able to understand and see how this technology is used to conceive. First and the foremost is preparing the couple or the woman for ART. That is step 1. Step 2 is extracting oocyte or the sperm, either from the same person or else from the donor when we call it as homologous. And next, the type of fertilization method used outside the human body and how you are going to transfer, at what stage you are going to transfer. Either it is an embryo or gamete or zygote. Further, whether you are transferring into the autologous same person or to the different person. That is called as surrogacy. Once it is done, now you are going to monitor this precious pregnancy. So these are the 5 steps you need to understand. Then you will be able to appreciate the law. Let's go into the first step, preparing the couple. First and the foremost is evaluation of the couple and to investigate what is the cause for infertility. The definition of infertility is, as per the legislation, if 1 year unprotected intercourse does not yield pregnancy, then it is considered as infertility. And now, what is the reason for this infertility need to be understood, investigated? What are the causes which are playing important role? Whether the affordability, the cost, hormonal treatment, side effects. Is there any comorbid medical conditions, either in the husband or in the woman? And also, whether is there a possibility of spontaneous conception or else there is a need for intervention. And first, you will try a medical treatment, and then if it is a failure, then only you will be considering the intervention method. Above all, this first step will determine what type of ART is going to choose. I am repeating, the first step is very, very essential. Based upon these important factors, the type of ART is chosen. Moving to the second, that is retrieval of oocyte or sperm. It is either from the married couple or for a woman who is unmarried and she can donate oocyte, or else from a married woman who has a single child can also donate oocyte, or else it can be by a donor by a third party, or else the same person in the young age she has given the oocyte which is frozen, which can be again utilized. So that is also possible, or else the fresh egg or the sperm is used. So either it can be what I mentioned, autologous or homologous. The same person or from a different person can be used, and the collecting, that is a retrieval, is also very essential. And how it is stored, either in the bank, and how these are monitored needs to be kept in mind. So that is the second step. Moving to the third step, fertilization, that is in vitro fertilization. Here, since they are unable to conceive, you are going to take the gametes outside the body and you will be controlling the environment and fertilizing them. Whether it is mixing or else intracytoplasmic injection, and how you are going to deal the situation will decide about in vitro fertilization. Moving to the fourth, that is transfer of the embryo, gamete or zygote, whichever we are going to transfer. Based upon that, the name is called. Here, you can use surgery, that is laparoscopic surgery, or placement directly into the fallopian tube, or else directly through the uterus. So depending upon various methodology, comfort and affordability, the methodology will be used. Either you can transfer into the uterus, as I mentioned, or into the fallopian tube. It to the same woman who wants to conceive, or to a donor womb, that is basically renting the womb, surrogacy. So depending upon the stage, placement, the fourth step will occur. And the fifth step is closely monitoring the pregnancy, either in the woman or the surrogate mother. So these 5 important steps are I mentioned, but now there are too many stakeholders are involved, such as ART clinic, ART banks, which are going to store, retrieve and store these oocyte and sperm, and then the doctors involved. At the same time, the donors who are involved, either the donor of the egg or donor of the oocyte. At the same time, along with the doctor, there are many other people involved in retrieving and fertilization and transferring to the mother. At the same time, the donor can be not only with regard to oocyte and sperm, even the renting the womb, that is surrogacy. So considering that too many people are involved, at the same time, the birth of this child through art, imagine, we need to consider the risk involved in this procedure. In rare situation, the death of the mother can occur, or else the death of the child or disability of the child. There are too many ethical and legal issues surrounding this. Hence, there was a need for this ART legislation. Let's look into the ART industry. Again, as I mentioned, medical, legal, ethical issues are starting from choosing the couple or so-called commissioned couple, extracting sperm, oocyte from the same person or from a donor, how you are going to store them, and who are the people involved in it, the donors, what should be the donor, how you are going to examine the donor, check for any genetic diseases or infective diseases. If a mother or a lady is renting the womb, whether she has any illness, if the child is born, whether it has the rights equivalent to biological child, or else if the child is not healthy, whether the child can be dumped. These are the commonest problems which have been seen when this ERT is unregulated. And further, commercialization of this assisted reproductive technology is creating trouble across the world. Hence, the need for legislation was thought. The government of India had been working on this legislation to regulate ERT industry since 2008, when it was first drafted by the ICMR. But however, it was more of a guideline. Hence, there was no hard law. That means the law which can be implementable and punishable if there is somebody contravenes the law. And there is a rapidly growing industry without regulation. Hence, the law was passed in the parliament. And this was considered as very essential to regulate the medical, ethical, and legal issues surrounding the assisted reproductive technology. So this law was passed on 18th December 2021. And this law is considered as one of the landmark advanced medical technology legislation. And it is considered as one of the landmark. The reason being is we are in par with Western world with regard to technology in the medical field. Hence, this legislation is very essential. And the legislation is called as the Assisted Reproductive Technology Regulation Act 2021. Here it has 46 clauses and 6 chapters. Let's look into those chapters. Chapter 1 is preliminary and definitions. Chapter 2, who are the people who are going to regulate this assisted reproductive technology? That means there are statute bodies formed under this legislation. Who is going to monitor this clinic, monitor those banks, and also the people who are going to work there. So that is very essential. Hence, the authorities have been clearly mentioned. The third one is procedure for registration of these clinics and banks. And at the same time, we need to know who are the people who are going to work, how they are trained, what are their legal obligations. That needs to be clearly mentioned. That is in chapter 3. Moving to chapter 4, what are the duties of this assisted reproductive technology clinic and ERT banks? What they are supposed to do, what they are not supposed to do with regard to donors when they are giving the sperm or oocyte, when they are commissioned couple, they come there, how they have to treat them, what is confidentiality, how to maintain the registry, who needs to be disclosed, whether the donor name should be disclosed or not, how the identity will be established. All those has been clearly discussed in chapter 4. Moving to the chapter 5, offences and penalties. If somebody contravenes this law, they need to be punished. That have been clearly defined in chapter 5. And chapter 6 is miscellaneous. That is, how the rules are made, what is the responsibility of central government and state government are discussed in chapter 6. Let's discuss each one of them. Chapter 1, preliminary. Here, the preamble is very clear. The preamble clearly says that this is a legislation to regulate and supervise the art clinic and banks. That is, assisted reproductive technology clinics and banks need to be regulated and supervised. Further, prevention of misuse, safe and ethical practice of assisted reproductive technology. That means we need to say it is not misused. It is safe for the couple, the mother and the child. Further, we are discussing about genetics, that is eugenics. Whether we are going to manipulate the genes, whether we are going to select a specific sex. Hence, ERT research and development also is monitored under this legislation. So there are 3 important objectives of this legislation: monitoring the clinics and banks, prevention of misuse, ethical practice, and finally, research and development. So this is the main objective of this legislation. Let's look at the definition. What does this ERT technology define? Assisted reproductive technology is defined in this legislation as with grammatical variation and cognate expression, because many people will change the words because depending upon their English skills. Hence, they are clearly mentioned. Grammatical variations and cognate expressions means all techniques that attempt to obtain a pregnancy by handling the sperm or the oocyte outside the human body and transferring the gamete or the embryo into the reproductive system of a woman. The definition is very clear. Here, manipulating or influencing the oocyte or the sperm outside the human body and again transferring into the woman. So that is the simple, clear definition as per the legislation. Now, what is this ART bank? ART bank means an organization which shall be responsible for collecting of gametes, storage of gametes and embryos and supply of gametes to the assisted reproductive technology clinics or to the patients. So these are the banks which will supply. So that is the definition as per the legislation. Moving to the clinic, ART clinic. ART clinic means any premises equipped with the requisite facilities and medical practitioner registered with the National Medical Commission for carrying out the procedures related to ART. As I defined in the definition, so any premises, it need not be hospital and the doctor may not say, no, I am practicing at home. So any premises which calls it as a ART clinic, there are some minimum standards has to be maintained and to be fulfilled. So that is the definition of clinic. Moving to the commissioning couple. Commissioning couple means any infertile married couple. See here, it is not any couple, it is a married couple. Unfortunately, unmarried couples have not been included in this legislation, and that is one of the drawbacks of this legislation. But however, let's focus on commissioning couple means an infertile married couple who approach an assisted reproductive technology clinic or assisted reproductive technology bank for obtaining the services authorized for the said clinic or bank. That means the commissioning couple may be married couple and who have infertility. That means more than 1 year unprotected sex has not yielded pregnancy. They can either approach the clinic or the bank for the purpose of getting the ART services. They are called as commissioning couple. Let's understand what is embryo. Embryo means a developing or developed organism after fertilization till the end of 56 days. From the 57 days, it is called as fetus. So, embryo means from the day of fertilization to 56 day, it is considered as embryo. So, from the day of fertilization. So, you have to be very clear because there are sometimes you call it as embryo, sometimes you may call it as zygote, or sometimes you call it as fetus. So, this is the definition of embryo. Now, let's understand what is gamete. Gamete means sperm or a oocyte. Gamete donor means a person who provides sperm or oocyte with the objective of enabling an infertile couple or a woman to have a child. So that is gamete donor. So these are the various definitions which have been clearly mentioned in the legislation. Again, as I mentioned earlier, infertility means inability to conceive after 1 year of unprotected coitus or other proven medical condition preventing a couple from conception. One of the best example I can give is blocked fallopian tube, or else in male there are various reasons their sperm count can be less. Like for example, cannabis use. If a person is cannabis dependent, the sperm count decreases and they are unable to conceive. In such a scenario, ERT is very, very helpful. Moving further, let's discuss about chapter 2. That is authorities to regulate this legislation. Who are those authorities? There are 3 important authorities have been formed. One is National Assisted Reproductive Technology and Surrogacy Board. Here we are mentioning Surrogacy Board. There is a separate legislation with regard to surrogacy. I'll be discussing in a separate video. And please go and look into that video. Second one is State Assisted Reproductive Technology and Surrogacy Board. That means we have National Board and State Board. The third one is National Assisted Reproductive Technology and Surrogacy Registry. it is considered as registry. And also the appropriated Assisted Reproductive Technology and Surrogacy Authority. That means we are talking about national board, state board, and the third one is registry with appropriate authority, either at the center or at the state. So these are the three statute bodies have been formed under the legislation to monitor the implementation of the act, and also how this act will be regulated, rules will be written, and the role of the central government, state government, and how these clinics and banks are monitored will be discussed. So as I mentioned, there are three important. In a simple word, I can call it as National Assisted Reproductive Technology and Surrogacy Board at the national level, state level Assisted Reproductive Technology and Surrogacy Board at the state level, National Registry and authorities either at the central and the state. So these clearly are discussed how they have to be established, what are the powers of each of these boards, registry and authorities, and functions, and how the members are nominated, terms and conditions of these members, salaries. All those have been clearly laid out in the Act, and some of them need to be drafted in the rules. Now let's discuss about the National Assisted Reproductive Technology and Surrogacy Board. This is the board which will be advising the central government with regard to policy matters of ART. Implement of the Act, rules and regulations will be done by the National Assisted Reproductive Technology and Surrogacy Board to lay down the code of conduct of persons working in this clinic and banks. That means the people who are working should not give information to the other people regarding the donor, the person who has come for treatment. Those things, how they have to behave, the code of ethics will be clearly mentioned. And supervising the bodies and registries and authorities. That means the national level will be monitoring the state level board and also the registry and authorities. Moving to the second, that is State Assisted Reproductive Technology and Surrogacy Board. This is the board which will be implementing whatever the national board policies, rules, regulations have been drafted, and they are responsible at the state level. Moving to the third one, National Art and Surrogacy Registry. Here it is a registry. That means here the National Registry of the people who have commissioned for the ART, the donor's name, and also the donor's name of the sperm and egg, they will be registered. And further, what are the side effects? What are the outcome of this? And there is, if required, any research to be done, that will be done here. So, National Registry of Clinics and Banks, nature of services and outcome of these services, research based on the above data, and using the data to advise the National Assisted Reproductive Technology and Surrogacy Board. So this is very essential. This has been said many years back, telling that we need to have a registry because tomorrow we may end up having only male children, because this technology can easily detect whether it is a male child, female child, whether we want to have only intelligent children. And also many a time, we don't know what is the outcome of this ART technology. Hence, the National Registry is very essential. Hence, this has been clearly drafted here. Registry with authorities. Authorities may be at the central level and also at the state level. So, these authorities is basically to enforce the minimum standards for this clinic and banks, to investigate the complaints under the ART Act, rules and regulation, to take appropriate legal action if there is a misuse of this technology, to implement the acts and rules, and to take action against banks and clinics if they violate this legislation. So authorities will be the main implementing agencies both at the state and also at the union territory. Moving to the chapter 3. Procedure for registration. That means all these clinics and banks need to be registered. ART clinics and banks must be registered before they provide services. Once the legislation has been implemented, that means within 60 days, they have to register. The authorities which I mentioned at the state level and the union territory level, they can either register, reject, or give explanation for not processing the application. And here, authorities will inform the board at the state level and also at the central level. The board shall inspect these premises before giving the registration, both the ART clinic and ART banks. And each registration is valid for 5 years. And these registration certificate needs to be displayed in the clinic and also in the bank. State authority decision with appeal is to the state government. Imagine if the application is rejected, the person who is in charge of the clinic or bank can directly approach the state government. If it is in case of union territory, they will approach the central government. Moving to the chapter 4. Duties of this ART clinic and bank. This is a very important chapter with regard to clinics and banks, because this is the chapter which will say what to do and what not to do. If they do anything in the contravention of the law, either by a doctor or a technician who is working there, how the donor is chosen, how the commissioned couple is chosen, how they have been charged, whether it is a commercialization, whether there is unethical practices, whether there is a selection of the gender of the child is done, all those things has been discussed here. And this is a comprehensive chapter. And I request all the doctors to go through this chapter 4. First and the foremost, ART clinic will procure gametes from the registered bank. That is very essential. Or ART clinic can have their own banks. That means mixed methodology. They have to take it from the registered bank. That is very essential. Donors should be screened for diseases. And these diseases will be prescribed by the National Assisted Reproductive Technology and Surrogacy Board. What are those diseases to be screened? How they are to be screened will be told by them. Confidentiality of the donor and the commissioned couple has to be maintained. Under no circumstances it will be revealed. It will be revealed only for the National Registry for registration, and under medical emergency with the consent of the commissioned couple, that can be revealed to only to that couple and for competent court. So only these are the 3 people are eligible to know who are the donor and who are the commissioned couple. Otherwise, it cannot be revealed to anybody. There should be a grievance cell both at the ART clinic and also ART bank. And further, ART services should be given to the woman aged between 21 to 50 years, whereas man can avail these services between 21 to 55 years. Once they avail these services, discharge certificate have to be given about the services. Further, before starting the services, the clinic need to give counseling with regard to advantage of this ART, disadvantage of this ART, side effects, cost, risks, and also the rights of the newborn using ART technology has to be clearly documented. That counseling is a mandatory, because infertility and the cost involved, anxiety, for that the counseling is very mandatory. Further, the clinics also has been mandated for the information to the National Registry with regard to enrollment of the commissioned couple. They are infertile couple who have come for treatment. Woman and the male donor of the gametes has to be clearly informed to the registry. Procedure undertaken, what are the different types they have done, outcome of these procedures and complication of the procedures need to be informed to the National Registry. Further, under section 22, it talks about the informed consent. Written informed consent is a must for all stakeholders. That is commissioned couple, women, men who are donating either the egg or the oocyte. And also, if there is a cryopreserve has to be done, then the consent has to be taken to preserve. And by chance, if the death of the donor is there, what should be done has to be clearly mentioned in the consent. And also, prohibition of using this material obtained during the art for any other purposes, maybe research or doing something else. So those has to be clearly documented and consent has to be taken. And prohibition for apart from using for ART is completely prohibited. Insurance for the oocyte donor for 1 year has been clearly mentioned. Imagine, oocyte has to be extracted, and if there is a possibility, because it is a invasive procedure, something goes wrong to the donor, that means she has to be covered by health insurance for a period of 1 year. Commissioned couple or a woman can withdraw the consent from the ART before placing the embryo or gametes to the concerned uterus. That means they cannot do once it is placed. The consent is valid till the placement. Imagine after the placement they can't withdraw because already the process or the cycle is set in and the fertilization has occurred, and by chance if the pregnancy is continuing, under no circumstances the consent can be withdrawn. Before that they can withdraw the consent. Further, section 23 talks about the medical records. These clinics and banks need to keep these medical records, and the records with regard to the couple, women, for 10 years they have to keep. And by that time, they have to update the National Registry, telling that these are the people who are given the commissioned couple, the donor's name, outcome, all those things need to be clearly mentioned. Any closure of the clinic, imagine the clinic is closed because of the financial reason or the doctor has died, those records need to be transferred to the National Registry. Just you cannot close and walk away, because these are all very important records and these need to be shifted to National Registry. Further, these clinics and banks need to facilitate inspection of records by the national board or the National Registry or the state board or to any other person authorized by the national board on behalf of them. That means they need to allow this when there is a clear-cut mandate that they come and inspect. Further, under Section 24, the gametes, how they have been considered, stored and retrieved. Here, the clinic shall retrieve the oocyte in such a manner as may be specified by the regulation. That means how it will be done, what are the sterilization mechanism, what is the qualification of the doctor, what should be the clinic, how many oocytes can be taken, all those things, again, regulations will be coming in. But again, they have clearly mentioned in the legislation, not more than 3 oocytes or embryos may be placed in the uterus of a woman. That means you cannot have quadruple. It has to be either 1, 2 or 3. Maximum 3 can be presented into the womb for conceiving. A woman shall not be treated with the gametes or embryos derived from more than one person or one woman. That means during the treatment cycle, you will not mix the sperm, or else you will not mix the oocytes from 3 different people or 2 different people. Hence, it has been clearly prohibited. In one cycle, it will be one donor only. Either it may be gametes or maybe the oocyte. No mixing is allowed. Further, the embryo shall not be split. That means cleavaging is done. So the embryo is split. The same embryo can be given to 3 or 4 people. That is not allowed. That is a commercial purpose. They may do it. That is not allowed here. The collection of gamete posthumously, the person has died and they want to take the gametes from the died person, is not allowed unless the commissioned couple has given consent before in hand. The clinic shall not use the ovum that are derived from 57 days in a process of in vitro fertilization. If it is 57 days, it is considered as a fetus as per the definition of the legislation. Now, let's discuss about the pre-implantation genetics. Before implanting the ovum, embryo or zygote, they need to be tested. And these pre-existing illness, heritable or genetic diseases need to be screened by the approved labs. All embryos before implantation needs to be checked. Donors and recipients need to be screened. And the National Assisted Reproductive Technology and Surrogacy Board will specify what are those tests to be done before implantation. And now, very important, Section 26. Sex selection is not allowed. And it clearly says, the Preconception and Prenatal Diagnostic Technique Act of 1994 will not be violated at any cost. And the clinic shall not offer to provide a couple or a woman with child of predetermined sex. They will not test it. They will not offer that we will give you only male child or female child. That is not allowed. Even advertising will be considered as a contravention of the law. It is prohibited for anyone to do any act at any stage to determine the sex of the child to be born through the process of ART to separate or yield the fraction enriched with sperm X or Y. That means it is completely prohibited. Either in this legislation or PNDT Act, clearly it is said it is not allowed. A person shall not knowingly provide, prescribe, administer anything that shall ensure or increase the probability that an embryo shall be of particular sex, or that shall identify the sex of an in vitro embryo except to the diagnosis, prevention and treating the sex-linked disorder or disease. See, it being clearly mentioned, neither the doctor or any person involved in the clinic or the bank will not either do sex selection or else offer sex selection. That is completely prohibited. Now the question of sourcing of gametes in Section 27. The screening of the gamete donors, the collection and also storage of semen, provision of oocyte donor shall be done only by a registered bank. That is clearly where the sources are done and how the screening is done is clearly mentioned. Further, the bank shall obtain semen from the male aged between 21 to 55 years after the screening. Second one is oocytes from the female aged between 23 to 35 years. That is only short period. Screening of donor for diseases is a must, and these diseases screening will be dictated as per the National Assisted Reproductive Technology and Surrogacy Board. Further, a bank shall not apply the sperm or oocyte of a single donor to more than one commissioning couple. That means the same embryo or the oocyte or sperm will be not given to too many commissioning couple. It will be 1:1. A oocyte donor shall donate oocyte only once in lifetime. Not more than 7 oocytes shall be retrieved from the oocyte donor. That means a woman can donate once in a lifetime and not more than 7 oocytes will be collected. They have been clearly mentioned. Further, all unused oocytes shall be preserved by the bank for use on the same recipient, not for some other, or given for a research on an organization registered under this act after seeking written consent from the commissioning couple. That means if there is unused oocyte is there, or even the semen, it cannot be used for other commissioning couple. It has to be for only one recipient, and later it has to be discarded, or else it can be given for research. Only the commission couple has given the consent. Further, a bank shall obtain all necessary information along with the Aadhaar card for identification purpose. Maybe this can be considered as a violation of Justice Kuppaswamy versus Union of India 2018. There was a landmark decision, but this law clearly brings in this Aadhaar identification is to be done. Further, the storage and handling of these oocytes and gametes are clearly prescribed under this legislation, under the regulation or the rules. Storage will not be more than 10 years. After that, they will be allowed to perish or donated for research with the prior consent. Human gametes and embryos or their transfer to any country outside India is completely prohibited. That means you cannot transfer the gametes, embryos to the other country. The research on human gamete or embryos within India shall be performed in such a manner as may be prescribed. That means if somebody is doing genetics test or genetic research, that means this legislation is going to monitor them. Further, the child who is born from this ART technology, what are their rights? Section 31 clearly put those in word. It clearly says the child born through ART shall be deemed to be a biological child of the commissioning couple, and the said child will be entitled to all rights and privileges available to the natural child only from the commissioning couple under the law for the time being in force. That means the commission couples, the child will be considered as their biological child. Further, it clearly says a donor shall relinquish all parental rights over the child, or children may be born from his or her gamete. That means it is the commissioning couple will be the biological parents, and their natural whatever rights are there will be given to the child. The donor will not have any kind of guardianship or any parental rights will be given to the donor. Coming to the chapter 5, that is offences and penalties. This legislation is very, very strict because we are dealing with a very sensitive ethical, medical and legal issues. First and the foremost, Section 32 clearly says sex selective assisted reproductive technology is completely banned. Even advertisement is considered as punishable. Punishable up to 5 to 10 years imprisonment or 10 to 25 lakh rupees fine or both. That means imagine somebody is giving advertisement, we are going to give you healthy male child or healthy female child only, is a punishable offense. That means sex selection is not allowed. Further, under Section 33, some important contraventions have been named. First, if the child which is born through ART cannot be abandoned, disowned, exploited, or else if you are going to harm the child, is not completely allowed. That is Section 33. And further, it also says selling human embryos, gametes, running an agency or a racket, organization for selling or purchasing, trading human embryos or gametes is completely prohibited. That means commercialization is not allowed here. Further, import or help in getting imported in whatsoever manner the human embryos or human gametes is completely prohibited. That means You cannot import that. Further, exploiting the commission couple, asking more money, exploiting the woman or the gamete donor and telling that I will reveal the name, such kind of exploitation is completely prohibited. Transferring of the human embryo into a male person or an animal. Imagine, you cannot transfer the embryo to an animal or to a man. That is completely prohibited again. Selling an human embryo or gamete for the purpose of research, completely prohibited. You cannot sell it. That means commercialization is completely banned. Use an intermediate to obtain a gamete donor or purchase of gamete. That means using brokers. That is also completely prohibited. If there is a contravention of this law, what are the punishment? Section 33 clearly talks about the punishment. For the first time contravention is there, 5 to 10 lakh rupees fine is given. If the subsequent contravention occurs either by the clinic or by the banks or the people who are involved, the fine is 10 to 20 lakh rupees with 3 to 8 years of imprisonment. That means second time it is imprisonment is given. Moving to section 35. A complaint made by the national board and the state board or by any officer authorized by it, then only the complaint has to be received. And the complaint will be directly dealt by the metropolitan magistrate or a judicial magistrate of the first class to try the offences under this legislation. That means the statute is the only people who can give complaint. And all the complaints or offences under this are cognizable and bailable. Moving to section 37. By chance, if an offence is committed by the clinic owner or the bank owner or maybe somebody else inside the bank or the clinic, here the legislation by default says that the executive head of the clinic or the bank shall be deemed to be guilty of an offence and shall be liable to be proceeded against him for punishment. That means whoever is in charge of the clinic or the bank should be very, very careful. If somebody under them have done anything, even the head of this clinic and the bank can be punished. But however, the head of this clinic and the bank should prove in the court of law that the committed offence was without their knowledge. And at the same time, the head of this clinic or the bank should clearly prove that he had taken all due diligence to prevent the commission of such offences. That means by default, the head of the clinics and banks will be held responsible for any commission of crime or contravention of the law in the clinic or bank occurs. But he can only be allowed to walk away if he is able to prove that this offence were committed without his knowledge and he has taken all reasonable precautions to prevent the crime. Coming to the last chapter, that is miscellaneous chapter from section 38 to 46. Here it is the power of the central government, power of the state government, the power to search and seize the records in the clinic or maybe in the banks is given, further power to make rules and regulation, and there are additional, these law is an additional with other law. It is not going to replace any other law. That means it clearly says this is an extra law. You cannot say that I will be coming under only the ART clinic, I will not register under Clinical Establishment Act. Here it clearly says it is an extra additional law. It is not repealing or doing any other law. This is the new law with addition to any other health law. Now let's critique about this legislation. This is one of the best comprehensive legislation. And if you look at the legislation, they have well articulated and regulated, and some of the guidelines have been kept in either in the regulations or in the rules. And however, the surrogacy has been kept outside the purview of the act, and there is a new legislation has been clearly done, and I have been making another video regarding this. Please watch that. Further, there are clearly statute bodies have been formed under this legislation. Punishments are too stringent. Any kind of misuse, it will be punishable offence, and the owner of the clinic and the bank are punished if anything goes wrong below them. That means they need to be extra cautious. Further, this law is very clear. The owners are by default will be considered as a party to the crime. But however, the negative part is this legislation do not allow third gender, and the lesbian individual can go for the art technique, but gay, bisexual, transgender are not allowed to use this technology. Unmarried couple, single men are not allowed to use this. Further, if you read with JJ Act, single men are not allowed to adopt a female children. And now even Art Act is prohibiting. That means this is discriminating against men. That has been clearly criticized by many activists. Further, NART and the state board needs to give complaint to start a case against the clinic or the banks. To conclude, my dear friend, this is the law which was highly required in our country because ERT clinics and banks are mushrooming everywhere. And this is a very, very sensitive issue. We are talking about genetics. We are talking about selecting the sex. We are talking about the infertility, how the people will be managed, and who are the people who are going to manage these clinics, where the registration of these clinics and banks occurs. And at the same time, this legislation prohibits commercialization of the whole ERT technology. But the issue here is, if you prohibit commercialization, tell me who are going to invest in this costly affair? That is, who is going to invest in the clinic, invest in the bank, instruments, including the doctors who are going to provide services? That will be one of the biggest drawback of this legislation. Although legislation says we are prohibiting the commercialization. Although this piece of legislation is an excellent comprehensive legislation. But however, prohibiting commercialization may hamper the growth of this industry. Wish this legislation would have regulated the pricing of the services. However, we need to wait and watch how the rules and regulations will be drafted. And at the same time, I request you kindly to go through the Surrogacy Act of 2021, which will be available in my channel. Thank you very much for giving your valuable time. Stay safe.